Okay then, I would say it's 10 a.m. The speakers are complete, so let's get started. Just have to do some fine-tuning here. Да. Уважаемые дамы и господа, мы очень рады вас приветствовать.
Dear ladies and gentlemen, we are glad to welcome you here. The topic is international trends and standards in M&A transactions. Let me introduce our speakers. I hope you will understand that the session will be in English because most of our speakers speak English better than in Russian. Same is true to me.
So I would like to start with the introduction then to my right side, according to the principle ladies first. We start with Axelle Tollemont. She's M&A partner of the law firm Gide Lorette Noël in Paris. And she will today represent the French view on things. And she's also the former head of the Moscow office of Gide. Then we have still in the auditorium Maria Miroshnikova. She's M&A and corporate partner of the law firm Ivanyan and Partners. It's a Russian law firm here in Moscow. No, in Moscow and here in Russia. And she will represent the Russian view on things later on as part of her own presentation. Then we have also to my right, Sang-Yoon Song. He is partner of Shin & Kim in Seoul. He will represent South Korea today. And he's doing corporate governance, M&A, private equity, and antitrust. Directly to my right, we have Simon Perry. He's an M&A partner of McFarlane's in London, and he will represent the English view on things. To my left side, we have Alexander Nikitine. He's partner of Walder Wyss, a Swiss law firm, and he will present the Swiss view. And then at the very left end, this is Alan Kartashkin. He's M&A partner of the US law firm Debevoise & Plimpton. He comes from the Moscow office and will represent the Russian view on the first part of this session. And we also have in the auditorium Valery Zinchenko. He's a senior partner of the Russian law firm Pen & Paper, and he has a particular expertise in criminal risk management, and he will later on make a presentation on a certain topic which is also related to M&A transaction. And last but not least, to myself, I'm Cornelia Tropf. I'm an M&A partner of the German law firm Gleis Lutz, and I will represent the German view on things and will also do the moderation today. So regarding some organizational stuff, we will split the session into two parts. So the first part will be a discussion on the general trends and standards on M&A transactions for all countries which you see represented here now on the stage, meaning Switzerland, France, South Korea, UK, Germany, and last but not least, Russia. And then this will take us about 2 hours, also including a short coffee break. And then we will continue with presentations of our Russian colleagues, Valerie, Maria, and Ellen, on certain specific topics in the second part. And we would like to ask the auditorium to actively participate in this session. So we would like to structure, in particular, the first part as more a discussion than a one-sided presentation to you. So I know that there are also other countries represented in this room, like, for example, Kazakhstan. And we would also be curious to know your view on things. So please get involved and raise questions and make comments on the topics that we have chosen. And last but not least, you will note that we have not done a presentation in PowerPoint form, which is very detailed. We only included headlines so that we leave enough room for a lively discussion. But in the end, we would like to offer after this session to send to you by email also a presentation with certain contents where we summarize what each of us told on the trends and on the standards in the relevant market. So if you are interested in this, please leave your business card then at the entrance. We will put a box over there sometime in the break, and we will send to you such kind of presentation. So now let's get started. I hope this works. Perfect. Close to perfect. Yes, that's what I'm doing. Can somebody help me? I think it should be self-explanatory, but apparently not for my purposes. Where do I have to point it to? So as you can see, we have chosen a couple of topics. Maybe the battery is too low. We will talk about... Now it works? Okay. We will talk about purchase price, material adverse change clauses, representations and warranties, limitation of liability, payment security, mechanisms, and general trends. And then we also have some surprises in the backup in case there should be some time left. So maybe if somebody could close the door, this would help a lot. So the target of our today's session is actually to answer a couple of questions. In particular, are there common standards and trends in M&A transactions worldwide or in continental Europe or in Russia? And are there certain local particularities which should be taken into account when you are doing a deal, for example, in France or in Switzerland or in Russia? And then, last but not least, and I think this is also a question that always plays a role here in Russia, to what extent does the governing law actually matter for the party's position? And if we start with purchase price mechanisms, there are a couple of purchase price mechanisms, and given that we do not actually know who's in the auditorium, we would like to introduce all kinds of purchase price mechanisms just with a couple of brief words. So it's possible to structure a purchase price with a locked box concept, which actually means that you have a fixed purchase price, which is not subject to adjustments after closing, but in return, seller would also have to do a commitment that he doesn't extract dividends from the target between signing and closing. So this is then the so-called no-leakage undertaking. This is the locked box concept. Then we have a cash debt concept, which actually means that you have a certain effective date, which is usually the closing date, and then you calculate the purchase price. You add cash, you deduct financial debt, and as an additional concept to this, and this is usually combined, you could have a working capital adjustment, which means that you also look at the working capital at the effective date. So not only cash is relevant, but also the accounts receivable and accounts payable. And then you would do a second adjustment on that basis if the certain reference value that you agreed upon has not been met. And then the other items like adjustment for capital expenditures, which have been made or may not have been made between signing and closing, could be included in the draft. And also some, I would say, more creative approaches regarding equity adjustment or certain earn-out mechanics. And I would like to start with the UK here. Simon, could you please give us an outline what you are seeing on transactions in the UK?
No, yes, of course. The usual choice in UK deals is between the locked box mechanism, which Cornelia outlined, which is adjust the purchase price before you buy, and closing accounts. As a very general rule, sellers will typically prefer the locked box concept because it gives them certainty before they sell, and it requires the buyer to effectively fix their price off what is effectively an unaudited balance sheet. Conversely, buyers typically will prefer closing accounts because it gives them greater certainty, and they will be able to adjust the price post-closing when they're in control. That isn't always the case. If you've got a business with very spiky working capital, It may be that actually you're better off as a seller going for closing accounts, depending on the term in the time in the cycle at which you are closing your deal. But applying those principles as a very general rule in a lockbox accounts are prevalent in a seller's market, closing accounts more prevalent in a buyer's market. Lockbox was very popular before the credit crunch in the UK, and it was certainly involved in most deals where both buyers were familiar with the concept. The pendulum has swung back recently, and we've been seeing a lot more closing accounts, although I think we are now beginning to see locked box come back again as the seller's market begins to return. I should say that in international deals where you have overseas buyers, particularly from the US or the Far East, then they typically are not so familiar with the locked box concept, and we're seeing more closing accounts in those types of deals. Just dealing with some of the other adjustments on the slide, I mean, the typical way in which you would adjust your purchase price in the UK would be on a cash and debt-free basis, and fix the price so that it's subject to a normal level of working capital. That isn't always the case, and it's obviously can be very business specific. If you have a business with a very high level of assets whose value may fluctuate, you may well go for a net asset value adjustment, but the same principles apply in terms of locked box and closing accounts. Just one more thing to note on the slide, earn-out mechanism is not very widely used in the UK. Where it is used is typically where you have a very people-centric business, and the sellers are individual sellers of a business who are going to be involved post-closing, so that it incentivizes them to carry on working for the business. But there are a lot of issues around earn-outs in that you have to put a lot of protections in place to make sure that the balance sheet is protected, and they're not commonly used in the UK.
Okay, thanks a lot. Chang Yung Song, how is this done in South Korea?
Okay.
Do you know the lockbox concept?
Yeah, lockbox is quite a new concept in Korea. Korean parties do not like purchase price adjustment post-closing. They tend to fix the purchase price in dollar terms in the definitive acquisition agreement. But you may notice a new trend coming up in Korea, because Korean legal market was opened last year, and currently 16 foreign law firms are operating in Korea, and 10 more are waiting to receive license. And by this, the foreign law firms tend to introduce lockbox and post-closing adjustment mechanism in the purchase price, and it may affect the Korean M&A practice. So I like focus on current practice in Korea. The reason why Koreans do not like price adjustment is due to they do not rely on the accounting methods, or they cannot easily agree on the true-up methods. Or as you say, if you even adopt GAAP as some adjustment mechanism, there may be some discretion on the seller or buyer. How can you make an apple-to-apple comparison between reference date and closing date? And it may lead to lengthy dispute, and it may consume management time in resolving issues. So that's the reason why Korean M&A do not like this kind of concept. Rather, in a private transaction, usually Korean companies have a controlling shareholder. You may have heard about the concept of Jaebol, large Jaebol company. And the controlling shareholder wants to get maximum value, and the buyer does not. And they want to make some kind of earn-out arrangement instead. So in the closing, they got paid some money, and then later, depending on the performance, they would get some more earn-out payment. And so I think about lockbox and working capital adjustment are a new concept, but it is likely to be permeating the Korean market. For example, ING Group is now trying to selling its insurance business in Korea, and they proposed the lockbox concept in the bidding process. And many Korean bidders are quite curious about the lockbox, how it works in the Korean M&A context. But it is set a standard. I expect more and more the international M&A mechanisms and the practice will come into Korean market. Thank you.
Okay, thanks. And Axel, what about France?
I must say that France, I think, is quite close to UK in that respect. We have an increasing tendency to have the locked box concept. I think it's not used in every M&A, of course, deal, but it's an increasing concept. The purchase price adjustment, if there is one, which is also quite frequent, would in most cases be on cash and net debt and working capital adjustments. I would say that the other adjustments which are mentioned here in the presentation, capital expenditures, defect capex, are quite uncommon. So mainly cash debt and working capital adjustments are used. As far as earn-out mechanism, same as for UK, we don't see that very often, and it relates to very specific deals where the seller would be an individual founder of a startup or internet business and would remain involved in the business. That in that particular concept, circumstances, we may see it, but it's in a very specific industry and type of deals. And the other thing which is very important to notice for France is that when you do have some purchase price adjustments, you need to be very careful about the way it's going to be drafted in the SPA, because there's always a risk under French law that the price would be considered as not determined or not being sufficiently, well, not, we would say determinable, being able to be determined with very objective criteria. And if the price cannot be determined with objective criteria, you have a risk of invalidity, because then you would have a real risk on your SPA. So that's a specific concern you have in France, and so you need to have expert clauses very clearly written. You need to have a last recourse with an expert, having no uncertainty even as to how the expert will be appointed. Everything needs to be drafted clearly to avoid this risk.
Okay, that's interesting. Thanks a lot. So, Alexander, how close is Switzerland to France in this regard?
Thank you, Cornelia. Let me say it's pretty close. However, I see deviations. I mean, basically, you see all types of purchase price adjustment mechanics. In Switzerland, the tendency is, however, clearly towards locked box concepts in easy constellations, where the company is not on a high operative level, and you would not really need for working capital adjustments. And the other trend that you see, in particular in life science industry, biotech, where the company does not have or just very little products on the market, is actually earn-out or milestone payments. So you would pay the price X, signing, closing, and then in the earn-out feature you would participate in a profit 1 year, 2 years down the road, or where you agree on milestones, which is really often the case. You would say, hey, look, I get another 10 million when you get when you reach phase 3, and another 100 million when you get FDA approval, and so on. This is something which is very often seen in the life science industry. Apart from that, in really big transactions, when you buy airport carrier, or a lot of valuation distractions, you would use cash debt and to combine with working capital adjustment, absolutely.
Okay, thanks. Ellen, I know that most of the transactions in Russia are governed by English law, but is there any difference also regarding the purchase price concept compared to UK?
I would generally say that Russian transactions are getting more sophisticated. If you look at the market trend generally, let's say 10 years ago, you didn't tend to have very sophisticated purchase price adjustment provisions. I think over the years, the market is getting more and more sophisticated, and although we're still not at the stage that you have in the US, when your purchase price adjustment provision could run for 5 pages in a document, we do start to see more and more sophisticated elements of purchase price adjustment, and that's why I think it's very interesting to see that this panel can provide this wonderful comparison across Europe. I think taking particular concepts. In my practice, locked box is quite rare. I mean, I've seen that used several times, including recently, but it's not the most common way to adjust your purchase price. Cash debt is quite customary. Quite often you have a working capital adjustment. It also depends on the industry. For example, a private equity buyer would tend to have a very sophisticated purchase price adjustment mechanism, including an earnout. And this is something that the sellers either understand or get educated in, that private equity deals in Russia, in my experience, follow the same rules that they follow in English transactions and even in US transactions, because private equity funds want to present the same product to their international institutional investors. But outside of the private equity world, I would say earnout is quite rare. A lot of the transactions we also do in Russia are in the natural resources sector. So there, the buyer is focused more on the license than even on performance of the company. And in those deals, you tend to pay maybe less attention to purchase price adjustment than in a private equity transaction where the buyer is focused more on return on capital. I would also say that, and this is a theme that I think will go from one slide to another, is that in Russia generally sellers want to have greater certainty. They want to have fewer purchase price adjustments. They want to have clarity about purchase price, and they want to have clarity about deal certainty.
So, but this would actually mean that the lockbox concept also for Russian sellers would be a perfect thing.
From that standpoint, that's true.
Yeah, to tell you how the situation is in Germany. In Germany, it has been trendy to have a lockbox prior to the financial crisis. But during the financial crisis, this changed again. And now we are more or less in a situation where, again, the purchase price adjustments based on cash, debt, and working capital adjustments are in the prevailing majority. When we are having a working capital adjustment and a cash debt adjustment, we will always have also an adjustment for capital expenditures, at least if we are having a buyer who knows what he does, because you always need an adjustment for capital expenditure to avoid that there are manipulations as regards cash, because if the seller from one day to the other stops capital expenditures to increase its cash or to keep it at a high level, actually you have a good cash position at closing, but the capital expenditures that you've seen in the business plan have not been met. So all those kind of more creative adjustments like equity adjustment, so a full adjustment on the basis of net assets, is really hardly seen on the market. So we only see this in very, very small transactions. Earn-out mechanisms are also very seldom, but we've seen this during the financial crisis, in particular to bridge the expectations of the seller regarding its purchase price and the valuation of a purchaser. And we've seen cases where there were certain additional purchase price components which depended on future EBIT of the target, for example. So are there any comments or questions on this point from the auditorium? So if not, we would go ahead to the next point, which is material adverse change. We have abbreviated this as a MAC because this is actually usually how we talk about this in practice. So we always have the differentiation between market MAC, a so-called market material adverse change, and a business material adverse change. And this concept, of course, only applies, or usually only applies, if we have a certain period between signing and closing where the transaction is pending because you need a merger control approval, and then buyer is in a certain situation that he wants to be protected against material adverse changes to the target or maybe also to the market as such. So if we start with France on this one, do you see material adverse changes in your SPAs?
Yes, we do see them. Of course, this is more buyer-friendly, so our seller would try to avoid as much as possible these MAC clauses. So it means that when there are some, they're quite hardly negotiated. And this would result in having some specific wording on the MAC. We would see more, for instance, company MAC than market MAC. And typically, the seller will try to avoid having very general MAC clauses, so they would exclude general trends on the market. They would exclude force majeure. There would be, very specific discussions on the definition of the MAC, and even trying to substantiate and define what is the material adverse change on the company. And the tendency would be to try to put a figure against it and limit the material adverse change to what is material in terms of amount. And this would lead to very specific discussions on the basis of the business of the company, of the size of the business of the company, etc. I would say that in France, the reason why we have this tendency to, when there is a MAC, to be very careful about drafting is that in most cases it would be a closing condition, meaning that the purchaser will be able to not to close the transaction if there is a MAC. And in most cases there would be no breakup fees. This is quite, breakup fees are quite uncommon in France. So if there is a MAC, then the deal doesn't close, and in general, no indemnity or no breakup fee is due. So it's quite harsh, and that's the reason why it's hardly negotiated. We often see it also the MAC clauses more as a warranty, as we were mentioning also in the items there. So it would not be a closing condition. It would just be with reference to the last audited accounts, representation of the seller, under which there has been no MAC event since the closing of the last accounts. So that's how it would work generally in France.
And can you say whether the majority of the transactions in France do have such kind of material adverse change clause, or it's the other way around?
I would say no. I wouldn't say it's the majority. As I was saying at the beginning, it's hardly negotiated. So I would say we see both, and I cannot say that the majority contains one.
And have you ever seen in practice a case where this material adverse change clause was triggered? So I will ask this question all other speakers, so you can already prepare.
No, I haven't.
Okay. So regarding South Korea, Chang-Yun, I've heard that there are some developments in the recent past which may create a certain tendency also to a market MAC in South Korea.
Yes. MAC is widely used in acquisition agreement in Korea. And the MAC affects the closing conditions, qualifies lifetime warranties, and then indemnification liability, and also even the termination right. And the market trend is single MAC. Say there is no material adverse change happening between signing and closing, is typically included in the Korean acquisition agreement. So any item that has a material effect to the business or operations company can, operate as a CP, closing conditions or termination event. And also, you should be careful about the double leaping of materiality. So that means there are so many material qualifiers in the reciprocal warranties, even in the termination clause. You must pass the materiality test if you claim anything in the agreement. So it is advisable for the buyers or sellers to clarify the threshold of materiality. So you can use the dollar term, certain performance standards, what constitutes the materiality or material adverse effect. And also, companies tend to use the boilerplate MAG, but now the attention moves to the general economic, social, and environmental issues. And also, Korea has recently undergone some tensions between the two Koreas, North Korea and South Korea. North Korea bombshelled Korean island 2 years ago, and they launched missiles and tested nuclears. And then they announced that they would activate the nuclear reactors. So this also increased the tensions between the Koreas. So generally, the negotiations focus on what would constitute the MAG or exceptions to the MAG. In general, the general market business conditions or changing exchange rate, foreign currencies are regarded as typically exceptions to MAG. But these days, now more attention is going to what constitutes the exceptions. So generally, we recommend our clients and buyers, especially foreign buyers, to look into the exception clause of a MAG, and because the new event is developing in Korea.
And regarding, or in case a buyer requests a material adverse change clause, which particularly addresses the crisis in North Korea, will this be accepted by the seller in practice, or is this only discussed and finally the parties agree something else?
Yeah, there is a strong resistance from the parties to include this as an exception to MAG. But the lessons from the past experience, the Korean financial market see very little impact from the North Korean threat. So now people think that now investors regard the North Korea threat as a rhetoric rather than a real threat. So market has some room to absorb this kind of risks. So though it is discussed, it is not firmly established practice. But as you see, the new leader, young and inexperienced Kim Jong-un came into power. Nobody knows where he has North Korea. The tensions are growing up. So it is worth watching out for what's going on. And it may be incorporated into the agreement if the tensions are going up in the coming days. And that's a practice. So generally speaking, people do not take much attention on the exceptions to MAG, but now the shift has to be made, considering the certain uncertain political situations in the Korean Peninsula.
Okay, and have you ever seen a material adverse change clause being triggered? Or being discussed?
It is very rarely triggered. But back in financial crisis in 2008, many of the M&A deals were canceled, and followed by many lawsuits. And the potential buyer invoked the MAG clause to cancel the deal and get refunded some earnest money deposit. And the court reviewed the case and refused the buyer's claim seeking to return the earnest money deposit. And it is very hard, very high standard to pass the MAG in Korea, like in the States. So although the buyer tends to make a MAG invocation, it is really hard to pass the judicial threshold.
So they often try it, but they seldom succeed.
Yeah, that's it. That's correct.
Okay,
Yeah.
Thanks a lot. Simon, what about the UK?
The UK is broadly similar to France in that we don't really see MAC clauses a huge amount in our deals, and where we do, they're more likely to be business-focused MACs rather than market-focused MACs. MAC clauses are much more common in financing transactions, and so if the buyer is obtaining financing from a bank, for example, then the availability of that financing is much more likely to be subject to a MAC, and it's in those cases that the buyer will not want to have any exposure for itself, where it may be forced to close under the acquisition and yet not have the financing. And so it's more in those circumstances where you would see a MAC being put into a share purchase agreement. This is also, should also be looked at in the context in the UK, in that unlike the US, for example, we will only ever have a split signing and closing if we absolutely require it. So if, for example, there's an antitrust filing condition or an anti-merger condition that needs to be satisfied. But if there isn't, we would normally have a simultaneous signing and closing, in which case the MAC condition obviously isn't an issue. One other point just to make we've been talking about private M&A deals. In public M&A deals, you cannot have a MAC. This dates back to just after 9/11, where WPP launched a takeover offer for Tempus. They had a MAC condition in their offer, but the UK panel on mergers and takeovers, which governs public M&A in the UK, refused to let them exercise that MAC. They tried to after 9/11, on the basis it was a totally different environment. And so ever since then, although in public deals you still have an actual condition which looks like a MAC condition, buyers should always be aware they can never actually exercise that. Have I seen a MAC being exercised? Only once, and that was used to renegotiate the deal more than anything else. That was actually a market MAC. It was a deal in Spain, and there were some very specific things in the market MAC which were tied to the rating of Spain's debt. There was a much longer gap period between signing and closing than was envisaged, and the rating went down, which triggered the MAC, and as I say, that was used to renegotiate the deal rather than anything else. Just to comment very briefly on breakup fees, I agree. Same in France. We don't see them very often, possibly on some of the very large deals. Again, in a public context, and this is something I'll touch on a bit later, it's no longer possible to have breakup fees. They used to be common, but not anymore.
Okay, thanks a lot. And have you ever seen a MAC clause being triggered, except for this case in Spain where it was used to renegotiate the deal?
No.
Okay.
No.
So, Alexander, have you ever seen a market MAC in Switzerland?
Absolutely. I think only very rarely you do not see actually MACs in Swiss SPAs. If as there is mostly a MAC, it's typically a business MAC and not a market MAC, so it would cover business risk within the company and within the group. It may even encompass prospects and so on, but not the market. You would exclude that. If so, you would structure it as a closing condition and not merely as a warranty and a covenant, and so which means also you can withdraw from the deal if you trigger. However, to me personally, the MAC is one of the most overestimated deal features. And as you suggested,
lots
with
of
questions,
discussions,
a lot of discussions, so don't let your lawyers spend too much time on negotiating MACs, unless they start to, in very detailed words, the impact as such. So if there's a clear reference to the loss with a reference to equity, sales, profit, and so on, then it starts to make much more sense also for the buyer. Otherwise, it's vague, and that's mostly the case. It's vaguely worded, and there's a lot of uncertainty attached to this MAC, and I've never seen a MAC triggered. Just in public M&A, it's allowed to have MACs in a public M&A context, public tender offers in Switzerland, and breakup fees as well. It's clearly consistent practice of the Swiss Takeover Board. They would allow you to introduce breakup fees in the deal documentation, typically in the range of 1% to 5% to cover costs.
Okay, thanks a lot. Ellen, what about Russia?
I would say that MAC clauses are quite rare in Russia. I've never seen a market MAC. You do see business MAC in certain deals, but as I said earlier, sellers want certainty, and you're more likely to have a very specific closing condition or a very specific representation with a bring down condition than to have just a more general business MAC. So I would say that market MAC would be a very unusual. Business MAC is possible, but not very common.
So have you ever seen one being triggered?
No. I mean, generally, Russian, I think people in the Russian market, they have higher tolerance for risk generally. And I think that explains why that issue maybe is not as important or not as commonly negotiated as it would be in a more stable country like Switzerland.
So what would happen in a deal in Russia when you have a material adverse change in the target's economic situation, but you don't have a material adverse change clause? Will there be discussions, or will it be clear that the purchaser is willing to close the deal?
I think generally sellers want greater certainty. So unless you have a very specific condition, you know, the general expectation would be that the deal would proceed once you have necessary regulatory approvals. Obviously, you know, many deals signed during the crisis did not close for various reasons. I mean, if a party, I mean, I must say that most of the Russian private M&A transactions are subject to UK law. But performance has to take place in Russia. So even if you have very few conditions, but the seller is not willing to perform or the buyer is not willing to perform, you're not going to be able to get specific performance in Russia, forcing the party to transfer the shares. So in that case, actually, you may end up you will end up litigating, usually in a forum outside of Russia, damages.
Okay.
You will not, I mean, this is, I think, an important distinction that I don't know if it's probably, I'm sure it's not the same in many other jurisdictions. But in Russia, it would be very difficult to force the other side to close.
Simon, you mentioned before that material adverse changes are customary under third-party debt financing. Have you ever seen a deal where such a material adverse change was included in the third-party debt, in the acquisition financing, sorry, but there was no material adverse change, and in the end, the purchaser had no financing in place at closing?
I can certainly, yes, I mean, it goes back a bit to before the financial crisis, and where buyers were willing to take the risk because they were pretty confident that if the debt that they were going for fell over for some reason, they would be able to get other debt.
Find somebody else.
I haven't seen it recently. Buyers are understandably more cautious.
Okay. Maria, do you have any comments on? Do we have a microphone also for the auditorium? Thanks.
I just would like something to the position as regards Russia. I completely agree with Ellen that application of a market mark is very rare. It's it would be more precise to say that they were not used before the economic crisis. And as regards business mark, I would say that the parties in the contracts followed the English law practice, and the business mark became a hot topic in the course of economic crisis when the buyers would like to not to go further and not to complete the deals. And there were a number of cases considered by the court whether there could be basis prescribed by law to terminate the deal based on business mark.
Okay.
And basically, I refer to the Article 451 of the Civil Code of the Russian Federation. And basically, the outcome of those cases was controversial, but the dominating position was that economic crisis could not be considered by the statutory business mark as a reason to terminate a contract by the party.
Okay, that's interesting. So as for Germany, I would say if you would prepare a list of the top 10 of the points that will always be requested by the buyers, the material adverse change clause is on number 2, maybe on number 1. So it's always requested, but it's often rejected. And we can say that in the majority of the cases, this doesn't make it to the final documentation. But we still have about, let's say, between 20 and 30% where we are having such kind of material adverse change clause as a closing condition. But in this scenario, it is always a business MAC. And we always define, or at least when we are representing the seller, we always define what means a material adverse change. And this is what we have also heard from the other speakers. So we have to define the adverse effect. Is it a certain loss of a certain amount? Is it a certain loss in turnover? Is it a certain EBIT number that has not been achieved, although it has been included in the business plan or something like that? So you have to be very precise to give at least the seller a certain certainty that he knows when the MAC is triggered and can then accordingly respond. But same for me, I also have never seen a transaction where this MAC has been triggered. Are there any other experiences in the auditorium? Yes, please. So where's the microphone? Maybe if you can give it to me.
Just a couple of comments, kind of following up on a few observations made with respect to Russia.
You have to put it on, I think.
Can you hear me?
Yes,
okay.
Better now.
Vladimir Lekman, I'm a partner in charge of the Moscow office of Jones Day. As you pointed out, the vast majority of Russian transactions, particularly cross-border M&A transactions, are governed by UK law. But yet, there have been a number of very significant transactions governed by New York law, usually involving shares of companies publicly listed in the United States. And it's interesting that MAC clauses and those types of transactions are very standard because that follows US practice. And obviously when you go to UK practice and UK law governed documentation, you don't see those clauses in Russian transactions. But there's another peculiarity about Russian deals that I think worth mentioning here, is that in addition to using UK law, quite often the deal itself involves shares in companies incorporated outside of Russia, because a lot of Russian business groups have holding companies actually incorporated in other jurisdictions. And that goes to the point that Alan made, because yes, it may be very difficult to force somebody in the absence of a MAC clause to close a deal in Russia, okay, but quite often that's not how it plays out. How it plays out is you would have an arbitration clause with dispute resolution, let's say LCIA, and then, you know, if you have a binding contract, you can actually get specific performance as a remedy. And then that remedy will be applied not with respect to shares of a Russian company, but with respect to shares of a Cyprus company, a BVI company, or elsewhere. And so that way, I think Russian parties should be very careful about, you know, having those MAC clauses as a way to, you know, possibly not be forced to close under those circumstances.
Okay. Thanks for your comment. So we would then move on to representations and warranties. And here I would like to start with Switzerland. What are you seeing in your transaction documents? Are you seeing comprehensive and extensive lists of reps and warranties covering each and everything? Also indemnities, which usually address specific items or which only are fine-tuned on certain findings from the due diligence?
So the rep and warranty section has become very standard, also in terms of form, but also content. It's typically a set of, let's say, 10, 12, maybe 14 reps reasonably worded. I would also say when you engage Swiss lawyers on both sides, they will find a solution within a short period of time, because there is a clear tendency towards reasonableness, weighted allocation of risk, and so on. So I think the tension has decreased significantly during the last few years when you discuss and negotiate reps and warranties. However, it really it becomes interesting when we we depart from reps and go into indemnities, which we typically have in the SPA, where you would not have, we would not be subject to the limitations, the other exceptions, which typically apply to the reps and warranty sections. And there we try, especially as a buyer, obviously, to get as much as possible into the indemnity section, which has become very standard, in particular for tax. Tax is now typically covered as a specific indemnity. You get full damage, full loss, no limitation, no de minimis, no cap, nothing. The other thing, when I mentioned that I personally think the MAC is not as useful, for a buyer to run away from the deal, as a buyer, when I represent a buyer, I spend much more time negotiating that the compliance with rep is a closing condition. And not only that, I ask for rep letters from the officers. And this is a much better opportunity, typically, that if you see a rep violation, which can be often the case, that you find a door out of the deal, instead of the MAC, which is or the standard, the level and the threshold is much higher. Disclosure concept is a big issue in Switzerland. So when you actually discuss reps and warranties, you spend a lot of time about disclosure. So which means the concept behind disclosure is whatever is disclosed cannot be used as a ground to file a claim on the damage violation, rep violation. So the sellers try to consider the whole due diligence room and data room as disclosed. And I have to say the tendency is clear towards accepting this approach, which is clearly different, I think, than we'll hear more on that in the US or in the UK, where you have specific disclosure. In Switzerland, I have to confess, the sellers can reach an agreement with the buyer to say, look, whatever is in the data room, whatever is disclosed to you also, sometimes during the business meetings, and which has put in writing at least somewhere and then put into the data room, it's deemed disclosed. Obviously it is, waters down significantly all the reps and warranties. What is else? Disclosure between signing and closing. Yeah, I think that's basically it. Again, the takeaway here is the real issue is disclosure. Otherwise, people and parties find solution with reasonable lawyers here.
What is usually the reference date of reps and warranties in Switzerland? Is it the signing date, or is it the closing date, or is it both? Or do you also know this kind of bring down concept where you repeat the reps and warranties at closing again, and then if you can't, you will have discussions whether or not the deal will be closed, whether there's an adjustment to the purchase price or whatsoever?
No, absolutely. So you typically you have reps at signing and closing, and then also that's also what I try to achieve when I represent the buyer, that I have bring down at closing, I have certificates, closing conditions signed by the officers, etc. Absolutely, yes. And so if it's a closing condition, the consequence would be that you can run away from the deal, and otherwise sometimes he would also allow you to file damage claim even though you would close the deal.
Okay.
So it allows you to, it's like an option. You say, okay, I closed the deal, but I reserve the right to file damage because of violation of the reps.
Okay. And is there any qualification on how the disclosure should be made in the data room? So we discussed this morning whether there's any certain document which hints out that there may be a pending lawsuit somewhere in a smaller country within the target group, but it's not under the litigation folder, but it's somewhere, I don't know.
Yes.
Yes. The marketing material?
Absolutely. You have that. You also have qualifications in many of the representation warranties, like materiality thresholds, knowledge qualifier, and these kind of things. So, absolutely, yes.
So, Ellen, how are reps and warranties being handled in Russia?
This is one of the reasons. Reps and warranties and also indemnities are the principal reasons why we use English law so much in Russia. It's because those concepts are not recognized under Russian law. And right now there is actually a draft amendment to the Russian Civil Code that introduces this quite, I think, alien concept into Russian law of representations, warranties, and indemnities. And this is, I'm sure this is, I know this is being discussed in some other parallel or maybe subsequent sessions that will take place today as part of the International Legal Forum, and a topic where I think every lawyer in Russia has a different opinion. But before, I'm not going to predict whether, well, I will predict that this is going to be difficult, I think, to adopt these provisions into Russian law, and even more difficult to implement them once they're adopted, because there really is this concept of representation, warranty, and especially indemnity is quite new to Russian law. That's why in every deal that you do under English law or any other non-Russian law, you would have a very extensive set of representations and warranties. I think if you compare them to both in terms of the level of detail and the scope to other jurisdictions, in particular UK, you will find that in Russian deals you would have more detailed set of warranties, more detailed set of representations. And I think it's partly due to the fact how this legal market developed when in the early days when people were coming into Russia, they were very worried about all sorts of risks, and they started out with a very long and detailed sets of representations and warranties, and that tended to stay in this market, and I don't think it's going to change. I would also say that what's interesting is that even in those transactions where you have to apply Russian law, or where parties choose to apply Russian law, typically, for example, if you have an M&A transaction between two Russian companies, a Russian company, or if a state entity is involved that insists on Russian law, then quite often you could have an SPA governed by Russian law, but have a separate deed of warranties and indemnities. So I think even in a context where you have to use Russian law, or for example, if you are selling an interest in an LLC agreement, there is a fairly new requirement that you have to notarize this agreement. And although there are now notaries who are willing to notarize deals subject to UK law, I wouldn't say it's standard, and there are questions whether this would be enforced. So in those contexts as well, you would have a Russian law sale and purchase agreement, but then you would have a separate deed to get the benefit of English law representations, warranties, and indemnities. Moving on to disclosure, I would say that contrary to the US practice, where you have quite often specific disclosure, where you say, with respect to this particular representation, I would like to disclose this particular fact. I think most Russian deals follow the UK approach, where disclosures are more general, So basically, whatever is in the seller will say that whatever is in the data room should be used as disclosure against all the representations and warranties. And it's quite also common to fix physically the amount of things that you cover by the disclosure. So if you don't have a disclosure letter and if you agree, if the buyer agrees to that everything disclosed in the due diligence should qualify all the representations and warranties, then it would be quite common to fix those documents either by handing them over at signing and a transfer and acceptance act where both parties acknowledge, well, this was the disclosure, or handing a disk with the electronic data room.
Okay, thanks. How would the, if you say it has become market standard to some extent to have extensive lists of reps and warranties, how would the first draft of a seller in an auction process then look like? Would this already include an extensive list, or would there be only some kind of face-keeping introductory offer and then the seller waits how the buyers come back?
Well, I think it depends on the style of particular seller and the style of particular firm. I don't think you would, anyone would really expect to get away with a very narrow set of representations and warranties, unless there are certain factors. Maybe it could be the case that this is such a prized asset that you think you can get away with it, or it could be. For example, if you're selling a minority stake in a public company, then you go to the other side of the spectrum. But I think we're more focused on the private M&A transaction when you transfer control. In that context, I mean, obviously the seller model will be much more toned down, but I wouldn't advise going with a very narrow set, because then what you get in return is you get the buyer's model. And it's not unusual for the buyer just to cut out everything you have in your draft and just insert his or her buyer's model of reps. And actually, some parties would even cut and paste whole sections of the documents. So I think that shows to me that Russian market still doesn't have a common understanding as to what is standard in a deal or not. Mm-hmm. Like you say in Switzerland, you think you can agree in a quiet gentleman discussion what should be the standard. I think in Russia those discussions tend to be quite more agitated, and I think there's going to be, typically you start out at the very far end of the spectrum with the buyer and seller, and then you try to move closer to each other. Unless you've done a deal in the past and you try to come up with a precedent, I think the sellers and buyers' positions are going to be quite far apart in the first draft.
Chang-Yun, how's your approach in South Korea on the warranties?
Okay, thank you. The first issue of when the warranties are given, a Korean practice is warranties should be repeated as signing as well as at closing. This is a quite well-established practice. When we do deals with the UK firms, the EU firms, they say that the warranties are given as signing, not at the completion date. Rather, that should be covered by pre-completion covenants. But in practice, in Korea, many buyers want the warranties repeated also at closing, because there may be some time gap between signing and closing, and most of the deals must go under antitrust reviews. It may take 3 to 4 months, so the company value may change during the period, so the warranties must be repeated as closing, and that's the prevalent marketplace in Korea. And secondly, the issue comes up with the general data room disclosure. Many EU firms now say that they want to qualify the warranties by making reference to general data room indexes or general data room disclosure. This is quite a new proposal in the Korean practice. And like the United States, many Korean firms do not accept this concept. The specific languages, specific limitations must be prescribed in the four corners of documents. Unless you specify your limitations to the warranties, you cannot get the benefit of general data room disclosure. And thirdly, there is some debate over sandbagging versus anti-sandbagging. If the buyer does due diligence, whether it strips the buyer from the benefit of warranties, generally speaking, in Korea, pro-buyer sandbagging clause is widely used. So the due diligence itself does not strip the buyer from enjoying the benefit of due diligence. And lastly, the line items of warranties. Generally, Korean documents include many typical boilerplate lapse and warranties. Also, you should take note of the specific warranty clauses in relation to labor and environment. Recently, Korean court ruled that certain fixed bonuses are included in or part of the ordinary wage. That means it will increase the allowance burden of the company. And according to certain survey, it may reach up to billions of dollars burden for the companies. So now GM told the Korean government that unless Korean government makes it clear, they will not make investment in billions of dollars. So now it became a national agenda. So the new government, President Park, is now pushing to clarify these issues. So in the context of M&A drafting, the buyer should put in the acquisition agreement that all the benefits, wages, and compensations have been properly paid in accordance with the laws and regulations. This becomes really important. And secondly, last week, Korean National Assembly passed the environmental law, the Chemical Material Management Act. It imposes very, very severe sanction against the violators. So, and the companies may be exposed to administrative fine of up to 5% of its total revenues. So it's really became an issue for the industry. So when you draft the agreement and negotiate the agreement, you should be keen aware of the compliance with law provision, especially with respect to labor and environmental. And that's the update of Korean law.
And are you working with representations and warranties on those specific items like employment conditions and environmental matters, or are you working with concrete indemnities? Because our issue is always that as soon as you have a disclosure scheme, the purchaser would later on have to look into the data room whether there is some hint on whether those kind of bonuses may not have been paid. And if this is the case, then he doesn't have any claims in case of a breach of a warranty, but he would still have a claim under an indemnity. Is this the same in South Korea?
Yes, correct. Even if some information are provided in the data room, typically in the virtual data room, it does not necessarily mean that buyer should be aware of the whole things. So the buyer certainly requests, if you want to get the benefit of the qualification, then must be specified in the disclosure letter or disclosure schedule. Otherwise, seller cannot be exempt from indemnification liability. So the prevailing practice is, if you want to qualify warranties, it should be provided in the document, especially the disclosure letter. That's the practice.
Thanks a lot.
Yeah.
Axel, how's the situation in France?
Well, in France, what we see is a very standard scheme of representations and warranties. I would say, with reference to your question earlier, that a first draft, even if in a competitive bid process, a first draft issued by the seller would always include a minimum set of reps and warranties. And I must say that I have seen maybe once a major deal without any reps and warranties, but it's quite unusual. We have this very standard scheme, which comes from Anglo-Saxon practice, but it's very standard in France. And I always find it amusing when discussing with Russian colleagues who expressed the fact that you cannot have reps and warranties under Russian law and you need to revert to a foreign law. Actually, it's the reverse thing in France. Same as Russia, we don't have any specific provision in the civil code or in the French legal environment enabling us to have reps and warranties. But it doesn't prevent us from considering that reps and warranties do work under French law, and we need them in a contract because there is nothing in the civil code. So it's always, we have the reverse position. The civil code in France gives very limited protection. We have a few of them, but they're quite limited. So we need the reps and warranties mechanism, and it's very, very standard. The trend that we see is, in addition to the very standard set of reps and warranties, is an increasing tendency to have specific indemnities. Unlike also some of the other jurisdictions, it's not so common to have tax indemnities, which are even quite rare in France, but the specific indemnities would, for instance, cover environment, same as Korea, and also some risks which have been identified during the due diligence by the buyer, and they want a specific indemnity to cover any materialization of these risks. And this is, I would say, very, very common in French deals to have it in addition to the classic set of reps and warranties. Concerning the disclosure, it's again quite specific in France because we don't have so much. We see the concept of disclosure letter, in particular from coming from experience in other countries, but it's not the main concept used in France. Usually, you would have representations in the agreement, and again, against each representation, an exhibit, very specific one, highlighting the exceptions to the representation. So there was no general disclosure letter, a very specific exhibits, and concerning the general disclosure of data room, of course, the seller would, in all cases, try to obtain it. And there are always a lot of debates and discussions, and I would say that the final result in France is half-half. We see the full disclosure of all data room, then we would, of course, identify either the list of documents in the data room or even the content of the data room attached. But, it's not 100% of cases, and we try, of course, to avoid it when we are on the other side. Maybe the last thing is the disclosure between signing and closing. Of course, we often need the reps and warranties to be repeated at closing, like in every transaction. What we would see is, since we have specific exhibits on specific reps, what we would see is the seller being authorized to add a few exhibits, a few disclosures between signing and closing, so that he would repeat the reps and warranties at closing, but maybe to take into account times and new risks, he could add some exceptions and some schedules, and we would treat it as either not excluding any indemnification, but at least there would be no misrepresentation, or we would treat it as being excluding from indemnification, except if these new disclosures or these new risks can be considered as a MAC. So it's a link with our other discussions. We would say, for instance, that the buyer can, disclose new elements, new risks, but if this risk can be considered as a MAC, then he would be able to get out of the deal. The buyer could be able to get out.
Okay, thanks a lot. Simon?
Like France, UK statute and common law gives very little protection to a buyer. the principle of caveat emptor or buyer beware normally applies. And therefore, for that reason, like everybody else on the panel, we tend to have a comprehensive set of warranties, which will typically cover all the business areas and focus on liabilities that may arise under those areas. The general points for discussion will typically center around risk allocation, because there will normally be a set of category of warranty where you can say perfectly fairly that is something that the seller knows about or ought reasonably to know about. But then there's a category of liability where you may say, well, actually the seller may not know about this, in which case, where does the risk lie between buyer and seller? And so one example might be a compliance with law warranty that extends worldwide, not just in the jurisdiction in which the business operates. And so to answer the question of how we would typically draft a set of warranties if we were acting for a seller, we would typically draw the line there, and so we would provide a relatively comprehensive set of warranties to reduce the risk of somebody coming in and putting their standard form on top of it. But we would sort of go out with the position that risk lies with the buyer of unknown items, and whether that's tenable or not will depend on the negotiating position between the parties. Risk allocation then also features when you're talking about whether you have to repeat your warranties at closing or not. And again, there's no set answer in the UK, in UK practice. It really depends on a number of factors, one of which will be why is there a gap period in the first place? If it's because the buyer has to go and obtain a license or something, you might say, well, actually, that's the buyer's risk, and therefore you may not repeat the warranties, or you may only repeat some of the very fundamental warranties. Equally, if the buyer is inheriting the economic benefit of the business from signing, which can sometimes happen, you might then again also say that the buyer should take the risk of the business at that stage. And so that's a debate which will be had on a case-by-case basis, and there's no right or wrong answer to that. Specific indemnities, the most common one in the UK is an indemnity for tax which has not been provided for and therefore has not been taken account of in the buyer's price, and that is normally pretty uncontentious. As in Switzerland, you wouldn't expect limitations on liability to apply to that warranty, to that indemnity rather. I should just add, you would still have a limited set of tax warranties, but they go more towards tax compliance rather than liability to pay tax. Other indemnities may arise, but purely on a case-by-case basis. So if there's a specified in liability which the buyer becomes aware of as part of their due diligence.
So pending litigation, for example?
So absolutely, pending litigation, an environmental liability, something which is specific and identifiable and which the buyer does not take account of in their price, then you would expect that to be covered by a specific indemnity. But there's no general rule on that other than tax. Disclosure, the position is broadly similar to everybody else. We would have a disclosure letter, but that will have two types of disclosures in it. It will have general disclosures, and it will have specific disclosures. However, both the general and the specifics will apply to qualify all of the warranties in the vast majority of cases. Obviously, as a buyer, you want to keep the general disclosures to a minimum, and the big debate, as people have identified, is normally around, do you generally disclose the data room? Again, there's no set answer to that. Practice in the UK is probably veering towards saying, yes, you do accept disclosure of that data room, particularly in competitive situations where a lot of buyers will simply accept that in order to get the deal done. on a similar vein, you might also, if it is a vendor-controlled process, there may well be vendor due diligence that's been prepared. And in that case, you might also say that everything in the vendor due diligence is generally disclosed. Disclosure between signing and closing, I touched earlier on whether we would repeat the warranties or not as a matter of course, but if we did, I would say the position is broadly the same as in France, in that you would typically end up in a position where you can allow new matters to be disclosed, obviously not matters that related to the period pre-signing, which the seller had simply forgotten to disclose the first time around, but new issues coming up, and you would then apply a level of materiality to those issues as to whether the buyer could terminate the contract or at least be given the leverage to renegotiate the contract. And if not, they would be forced to close and accept that disclosure.
And Simon, have you ever seen in the recent days kind of catch-all representations, like all information that is necessary to know for a reasonable buyer has been disclosed or something like that?
I've seen, in an M&A context, I've seen people ask for that, but it is very unusual to give it. You would typically see that kind of warranty more in an investment context in the private equity world, where the private equity house would be looking at the management team to confirm that they've told them everything they need to know. There it's much more common. In an M&A context, although you sometimes see it appear in people's first drafts, it isn't market practice to accept that type of warranty because it is so broad.
It's still on our top 10 buyers list that I mentioned before. Really? So does this apply to the others on the panel as well? Do you know this kind of catch-all warranties, or do you accept it, or do you request it if you represent the buyer?
I've seen it in the past, but I've never accepted it. It's unusual. It's a catch-all, very one-sided, I have to say. Then I rather, revisit the actual reps and the wording, and I might be, more forthcoming and accept any changes, but not a catch-all. I mean, there's no point in negotiating 2 weeks the reps and then give in a catch-all.
Same in France. I mean, I have seen people trying, but never accepted. And even, I mean, if I was on buyer's side, being reasonable and trying to avoid lengthy discussions on issues which will never be accepted, I wouldn't even think that if I was advising reasonably a buyer, I would ask for it in France.
Okay, then a couple of last words on the German side of the deals. I think it's more or less similar to what we heard before, with one difference, I would say. Of course, we also have a comprehensive list of representations and warranties that we are seeing in our transaction documents. But usually the first approach of the seller would be to limit those representations and warranties only to the signing date. And then we are having discussions representation by representation, which of those should also refer to the closing date. There are a couple of items, like, for example, title in the shares. Of course, this can be granted and should be granted also as of closing, but others, like pending litigation, which is far out of control of the seller, should not be given to closing. But of course, it is always subject to negotiation. And once we are having this kind of agreement that some should refer to closing, then again we would, as sellers' representatives, try to get the opportunity also to repeat our warranties with new disclosures as of closing, without this endangering the transaction certainty. And this is, I think, the main thing. But it's insofar it's the same as in the UK. We also say regulatory approvals which are required to close the deal, like approval from the European Commission, is a buyer thing, and buyer is responsible for it, and seller is not leading the process, so seller doesn't have any influence on the duration of time. And that's why we say, from a seller perspective, it's fair to limit the protection to the signing date. disclosure concept, this is also the same as we had it before, more or less. What we always try is to define what means fairly disclosed in the data room. And also this we have heard before, and we often use kind of a definition where we say fairly disclosed means I've put together the information in a comprehensive way that allows the seller, that allows the buyer to make its own risk assessment. So the buyer knows what he's buying and that he's buying into this risk. And then it should also count against the buyer. So we are now at 11:30. I would say there are still 2 points left. For the first part, we will make a short break now, and we'll meet again in 30 minutes. Thanks a lot.